Of course, that's subject to the New York Times or Sullivan case for public officials. Another category is what's called true threats. You can't threaten something. I'm going to beat you up. I'm going to kill you. Although that is indeed speech, it is not speech that's protected. Another category is obscenity or child pornography. Again, this is not regular pornography. Regular pornography, what you'll find, open up your web browser, you'll find it fairly quickly, is indeed protected by the Constitution. Obscenity is a certain type of sexual material that shocks the conscience, that offends certain standards of decency. And even then, I made this point last time, in our core society, I'm not sure what's obscene anymore. And there has not been a successful obscenity prosecution in quite some time. So in my opinion, that's not a particularly strong basis on which a category of speech is unprotected. Child pornography is no good, although the Supreme Court actually held if you Photoshop child pornography, that is, you take an adult and you make the person look like a child, that is protected. That was a case called Reno versus ACLU. The final category was the Chaplinsky case, the fighting words, that is, words that will bring you to fisticuffs, so to speak, are not protected. I have to stress that after you read the case in Texas versus Johnson, it should have been clear to you that the fighting words doctrine is not in very strong legs. If you imagine calling someone a goddamn fascist and burning an American flag, those would likely elicit very similar responses that would want someone to maybe punch you out. Johnson case didn't overrule Chaplinsky, but it basically made it not quite a dead letter, but something awfully close to it. So even though we have this fighting words doctrine in the case law, I would not put much weight in it. I really wouldn't, especially in light of the Texas versus Johnson case. All right. So the remainder then of our class is trying to figure out which category of speech it falls into. And depending on what category it falls into, we apply various tests going forward. If you've noticed, much of constitutional law is saying, oh, what bucket does this fit in? And then once we put it in the bucket, we figure out, what the correct test is. That's a common theme with much of our course. It's a course. Okay. Poor Nicholas. I was cursing my head off in front of him. What was that? I'm sorry. Yeah, I'm sorry about that. Did he hear anything or no? That was a really sweet note he sent me after class. Like, he wrote me a hand note like thank you for letting me sit in class. It was very sweet. Okay, fine. All right. It was really cute. I like having, it's nice. Bring your kid to ConLaw class when the professor was cursing his mouth off. So let's do the first case then. This is actually a fairly recent case, which perhaps you may have actually remembered reading about. Okay. Okay, where did I finish up last time? Oh, are you okay? Yeah, you ask a question. Go for it. Fighting words. Fighting words are words that make you want to fight. Like if I say something that's so offensive, your response is I want to punch you in the face. But again, that doctrine is not on strong legs. That doctrine is not on strong legs. And I really would not rely on it with any sort of case. So let's begin with our discussion, right, of Brown against Ime. So where was I? Who was last off? Are you next?
Yeah.
Okay, you want to give us, please, the facts for Brown, please?
There's an assembly bill that prohibits the sale of violent video game rentals to minors, and the respondents who represent the video game software industry, they brought a pre-enforcement challenge. Okay, good. And that was in the United States District Court of the Northern District of California.
Before we go through the actual analysis, walk me through, how did this law operate, Mirza? How did the law operate?
Are you talking about the rental, the assembly bill?
Yeah, how did the law at issue in this case operate?
It basically just it covered video games with a wide range of, video games with a range of player. They called them player options. So like killing, maiming, dismembering.
Okay, so certain video games that were in these broad categories involving killing, maiming, dismembering, sexually assaulting. These fairly broad category of video games were put into this label. Okay, good. And Heidi, once a video game was put into this label, what was the effect of this categorization? Was it going this way or that way? I don't remember. Okay, good. So what was the effect of that characterization after a video game was put into this label?
If you were, I think, under 17, you couldn't buy a video game unless an adult was with you, if it was categorized a certain way.
Okay, very good. So let me blow your minds here. So how many people ever snuck into a rated R movie when you were below it? Okay, all of us, right? Did any of you break the law? No. Believe it or not, the Motion Picture Association of America, which enforces the rating system for movies, is not a government body. Movie theaters voluntarily comply with this rating system because they don't want to get in trouble with various moms and people get upset, these sorts of things. The government does not enforce rated R movies. If you sneak, if you don't buy a ticket, that's a different story. But if a movie theater decides to go rogue and wants to show all these movies to children, there's no legal thing. Now, how many of you before you were 18 bought a video game that had the M for mature on it? Yeah, virtually everyone in this room. Did any of you break a law? The answer is no. This goes back, perhaps dating myself. Tipper Gore, Al Gore's then wife, she made her mission in the 1990s to try and keep violent video games away from children with Marilyn Manson and Columbine, all these horrible influences on the youth of today. So she was actually pushing for a federal bill that would have criminalized the sale of certain violent media and movies and video games to children. The industry was not happy about this, so that they instituted, like the movie theaters, a self-rating system where the industry would then rate their own video games, rate their own CDs, and they'd stamp a label on it. And then if you're Target or if you're Walmart or GameStop or whatever, you would know that we're going to comply with this thing, that we won't get regulated, right? This entire thing came about to avoid a federal bill, which in the 90s probably would have passed. This was before the internet was really a thing. Today with the internet, you don't need to go to a store to buy anything anymore. But back then, you had to actually go to a store to buy stuff. So we already have this sort of voluntary regime where video games and music are stamped, like M for mature, whatever, rated E for everyone. But the law at issue here sought to do something more. Okay? It actually made it a crime to sell a video game to a child or someone who I guess appeared to be a minor. They weren't really checking the child's ID, who appears to be under the age of 18. Under the age of 18, they have to have a parent or a guardian, or as Justice Scalia said, someone pretends to be at least, could be anyone really, come to the store and purchase the video game for the kid. Once the video game is purchased, there are no limits on whether the kid can play this game and do whatever he wants. Indeed, it's not even clear if the person has to be a legal parent or guardian. It could just be some bum they found at the mall who helps them get an art ticket. And whenever they did that, have someone buy a ticket for you? Of course. But in any event, this was the bill that California enacted to try to save the children from these awful things. Now, the worst part about this case, the case is called Brown versus EMA. When the case was decided before the Supreme Court, the governor of California was Jerry Brown. Who was a governor before Jerry Brown? Arnold Schwarzenegger. The case was 2 months away from being called Schwarzenegger versus EMA. When it was argued, that's what it was called. That was such a much better name for the case than Brown. Because like the most violent action hero of all time signed a bill that banned the sale of violent video games to kids. And the irony was delicious. But unfortunately, they substituted the parties after the case was argued, and we now have Brown, whatever. We have Schwarzenegger, right? But we have Brown versus the EMA, the Electronic Merchants Association. So the first threshold question, Lexus, is it video game speech? How is it? You and I are talking right now. This is speech. I wrote some stuff on the board. That speech. How is it video game speech? What does that mean, communicate ideas? Elaborate. You're on the right track. Give me a little bit more.
So it gives like a social message.
What do you mean social message? Like Twitter, or what are we talking about?
It creates, like you're playing these violent video games, like whatever, and it creates an idea in your head.
So like it communicates ideas and different thoughts. Right. So the first threshold question is that the courts have interpreted speech very broadly. The courts have interpreted speech broadly. It's not just the written and the spoken word. It applies to music, art, paintings, sculptures, dance. By the way, even nude dance. There was one case where a strip club started putting out productions of naked Shakespeare, claiming it was actually form of art. The strippers were actually performing scenes from Julius Caesar. You know, whatever. I'm not joking. You can Google this. But you know, you you can get creative. You can get creative, right? The courts have interpreted speech very broadly, and the court doesn't really even dwell on this point because you think, well, a video game is a bunch of code, like lines of code. Even computer code, when it's used to create these sorts of virtual worlds in these video games, is considered speech. Okay, so the first part of the analysis, like, is this even speech? Yes, it's speech. There's not any sort of issue there. I did this already, or you guys next? Yes, I did you already? No, but did I call you guys last time?
Yeah.
Okay, I'll go down here. I always skip this row. All right, so after we decide if something's speech, what's the next thing we have to think about in terms of our approach, our framework?
Is it whether it's protected or not?
Yeah, what category does this fall into, right? And I identified, it was 4 or 5, whatever it was, categories of unprotected speech. And for the last, I don't know, 30 or 40 years, the court hasn't added any new categories. Those 4 or 5 categories have been frozen. There was a time where the court would keep adding new categories. Oh, you can't do this and live, whatever. I think we're set in categories of speech. So what kind of approach then do we apply, Brody, if we're not? It's a protected speech. How do we approach this?
Whether or not it offends anyone.
What do you mean?
Whether or not it's going to be offensive to the kids they're going to be purchasing.
You're like 3 questions ahead. What legal approach we use if it's in a category of speech that's protected? In this case, what kind of scrutiny do we give? Why we give strict scrutiny?
Because it deals with a fundamental right of speech.
Okay. But specifically, what aspect of the law in question make it subject to strict scrutiny? What are they regulating? What is the basis of this stamp they're putting on the video games?
Well, I like how Scalia refers to, like, he talks about protected books, plays, movies before video games.
Good. That's good.
And he kind of compares them and puts them in the same category.
Byron, let me ask you a question. What about these video games put them in this like labeling category? What are they looking at?
I'm looking at, like, if it's fit for that particular age group.
What aspect of the video game? You're really close.
Kind of like the content of it.
Content. Bingo. Magic word. Content. The courts have said that when a regulation is based on the content of the speech, you afford it strict scrutiny. When the regulation is based on the content of the speech, you afford it strict scrutiny. We'll do a case later, the O'Brien case, the draft card burning. And in that situation, they said the law is content neutral, right? The law was made without regard to what the actual content was. Okay? But here, the law is expressly content-based. How do we know this? It says on the statute, if it has violence, maiming, killing, sexual assault, the entire 7 or 8 categories, right? So I think all the justices, Thomas accepted, agree that this is a content-based restriction, right? The dispute is over how strict the strict scrutiny must be. And this may be a point of a little confusion, but the court's free speech jurisprudence isn't quite so, how should I say, strict. An application of strict scrutiny for speech doesn't mean the government loses. And this is the point I think Justice Breyer tries to make in his dissent, that there are a number of cases where strict scrutiny applies for speech and the law is upheld. So to separate in your head, strict scrutiny for race is awfully strict. And then you have strict scrutiny for fundamental rights, which is pretty darn strict. And then you have strict scrutiny for speech, which is not quite as strict. So what torments students is the same phrase can have different meanings across different areas of the Constitution and yield different results. So I encourage you to try to keep those separate in your minds. But in any event, we have here a situation where there's a content-based restriction where strict scrutiny comes up. Okay? And Justice Scalia says, look, it's rare that speech restrictions ever survive strict scrutiny. Not never, not impossible, but rare. And I think Scalia is right about that. So as always with scrutiny, we look at what are the means and what are the ends. Okay? What are the means and what are the ends? What is the government trying to achieve and how are they getting there? So Scotty, what are the government means and ends? What are they trying to achieve?
The means, or let's see, well, the ends.
Start with the ends first. Yeah, that's fine.
They're trying to protect kids or the youth of California from these violent graphic video games.
Good.
And the means that they're doing it is by restricting their sale.
Okay, good. But they're not just restricting the sale. How are they going about restricting the sale?
By only allowing, I believe, adults of age 18 to purchase these graphic games.
Okay. So are they prohibiting the children from using these video games?
Not necessarily.
Ah, what are they actually doing?
They're adding a filter almost that the adults have to be willing to buy it.
Okay, good. So this is an important point to stress, right? This is not a situation where they're actually criminalizing the use of these products by children. They're not doing that. What they're actually doing is, you may say, reinforcing the parenting skills, right? They're reinforcing the parental involvement. Because as it stood before this law, if little Johnny comes home from school and mom and dad are not home, he can run to GameStop and buy Call of Duty, right? Or buy, Grand Theft Auto or whatever else. Now, you need to bring the parent into the situation, or someone who pretends to be the parent at least, someone who claims to be the parent into this equation. Now, Justice Thomas's dissent, which the book didn't include, it's an interesting read. He effectively thinks that children have no constitutional rights at all. He thinks that when they're minors, their parents have complete autonomy of their liberty, and this bill is perfectly sensible. So interesting dissent if you want to read that. But what Justice Scalia effectively says is the government has not shown that there is a close enough fit between the means and the ends. Okay? It's always a state interest protecting children. That's always an interest. But it's not clear that can pass strict scrutiny. So this is actually, I think, where Justice Breyer and Justice Scalia have the biggest difference. Justice Breyer's wife is a psychologist. He loves studies. He loves empirical data. And why am I talking? Robin, what's Justice Breyer's position? I mean, he states it, I think, quite clearly, but what is his general position with respect to this sort of law?
He says that the protection of children is important.
Good.
That depictions of violence are still something that is a matter of a choice type matter. So that there's no real, that the court is not really creating a new standard, but just applying other already established categories of speech.
Robin, let me ask you a follow-up, please. Does Justice Breyer discuss at all the effect of these video games on the kids?
Yeah, I think he talks about
We'll do the crush films in a few minutes. You don't think it's that? Does Justice Breyer discuss the link between children and how these video games affect them?
Yeah, he was kind of with understanding that when he made the current statement where like 13-year-old goes and looks at Playboy, has any person like him looking at the video game character from there, he's also like torturing her and feeding drugs and stuff. So he's saying like it's just inciting further violence and simple book or magazine might do.
Okay, good. Now, Breyer makes the point, I think, very well. Do we know for certain that playing these sorts of video games will cause this sort of violent conduct in these children. What was the judgment of the government here?
Basically, to like keep it from possibility of happening and try and monitor like what the parents decide.
Good. Ashley, I'm sorry. Sarah, coming back. If we're not certain that these sorts of video games cause the violence, why is Justice Breyer still willing to uphold this sort of law, even if we don't, it's not settled science? What's he makes? It's an important point he makes, and I'll give you a hint, Lochner. But what's Breyer's point here?
Well, he's basically saying that parents are to discipline.
No, you're giving me another correct answer. I want to focus on one point. Do we know for certain that playing these sorts of video games will invariably lead to this sort of violence? So then what should a court do in that situation?
There is a correlation.
Correlation. Okay, so anyone remember the statistics? What's the difference between correlation and causation? Correlation and causation. Oh, come on, yeah. Yeah. Very good. So correlation versus causation. You will now be much smarter whenever you see statistics, right? If you say, as the number of violent video games goes up, the number of school shootings goes up. Look, they're both going up in the same way. All that illustrates is absolutely nothing. It illustrates absolutely nothing. What you need to show is causation. And this is very difficult to show. The fact that the violent video games contributed to school violence, right? That caused it. It's one thing to say hypothetically that maybe watching these video games makes kids more violent. And maybe it's true, maybe it's not, I don't know. But the studies don't show causation. They only show correlation. And Scalia makes his point. But does this matter, Luis, to Breyer? Does it matter that we only have correlation rather than causation? Does that make any difference whatsoever?
Basically, it just goes off that it should be upheld, that it's not restricting anything, it's just an expression.
Why is he upholding it though? What's basing that upholding? You know, the studies don't show causation. Why is he upholding it?
It could be used as a purpose.
Who voted for this law? Who votes for laws? What's Breyer articulating here? Luis?
That the parents were the ones who
No,
voted
not the
for these
parents. Not the parents. Rebecca?
Deference.
Deference. Took 6 questions. Yeah, deference. Right. I was building up to it. Took a while. Deference. Breyer's entire point is deference. I think I mentioned this the first week of class. Deference. He wakes up in the morning and says, "Man, how can I defer to government today? Right? How can I make democracy work better?" His entire essence is deference. He's like, we don't know whether these games will make people more, screwed up, or whether these games will screw kids up. But if the legislature made that judgment, that's good enough for me. And in fact, the concurring opinion of Justice Alito and Justice Roberts, which is really a dissent. I mean, if you read it closely, they make the same point, saying, look, we don't know. Maybe these video games are different than books. I mean, we don't know one way or the other. We should be very hesitant before we go in and intervene, and we invalidate these sorts of laws, and we prevent the government from perhaps, we stop the government from trying to halt these things, right? Maybe the government can stop the next mass violence, the next brutality, and whatever else. But by striking this law down, we can't. So Breyer's dissent is basically Holmes and Lochner. I try and thread this through, but he's basically saying it's not for us to judge the wisdom of these laws. If the legislature makes a judgment that this will improve society, we should defer to it, even if the numbers aren't there and the statistics aren't proven. Of course, the big difference between Lochner and this case, not that it matters to Justice Breyer, is the First Amendment in the Constitution. It's right there, up top, page 1, right? Bill of Rights. This is an enumerated right, which generally gets some pretty close scrutiny. If you notice, Justice Breyer can't bring himself to use the word strict scrutiny. He uses the word strict, but not strict scrutiny. He can't even say it. He doesn't like this. For him, it's all about balancing tests and juggling up to 18 balls in the air. So Justice Breyer, as well as Justice Alito and Roberts, are hesitant to say, well, maybe the legislature's on to something else. Okay, but now going back up to Tariq, what does Justice Scalia respond to this? Are these video games something new that courts treat them differently? How does he respond to this? That this idea that maybe these video games are these new things that we should be very cautious before we advance, strong free speech protections too.
He said that hesitancy because that it was like we're initially reacting too quickly. New technology.
Yeah. What kind of examples does he give of this?
I believe he talks about. He talks about. I think he references animal cruelty. I know that.
Okay. Let me mention. Catherine, you're on deck. But I'll come back to the question in a second. So the case he references animal cruelty is the Stevens case. This was decided, I think, a year or two earlier. This involves crush films. Does anyone know what a crush film is? I was about to say you were all decent human beings, but then he raised his hand. So. Okay, so tell us what a crush film is, please.
Videotape themselves crushing animals.
So basically, you have these women in high heels stomp on little hamsters and kittens and rabbits. And this is a form of sexual gratification. People consume this as porn. Yes, do not go on the internet. Just don't Google this. If yeah, Samuel, I want to move away from right now. But the question in this case, right? It's without question that the government can ban the actual cruelty to animals, right? Police power. State can ban animal cruelty. That's why you have things like cockfighting and bullfighting and other things which are of perhaps illegal in different jurisdictions. But the question was, could you actually criminalize the sale of a video of these crush films? And the court invalidated the conviction, right? And they use examples saying, well, what happens if the government, started banning videos of hunting? Could do that. So the crush film was, they said, even something as grotesque as stomping on little furry animals, right? That was not something that could be banned the sale. You can criminalize the act itself, but not the graphical depiction of it. So Catherine, going back to the question I asked before, what are some of the examples that Justice Scalia brings forward to explain how in the past, people were freaking out at these new speech acts, that we got to, and the court did not, let it go.
I can't remember if it was Scalia or not, but what stuck in my mind were the parallel to books.
Yeah, okay, let's talk about that. Books, yes, books. You all read books before, right? I mean, you realize you're in law school, you probably don't have time, but you realize there's certain things you open up and you can swipe and you can read things. So what was the analogy of books?
He was saying that when a person or a minor, for that matter, reads a book, they're engaging with the characters. Interacting that way.
Interesting. So what Scalia basically says is, if you're in a really good book, you're immersed in this world, you're in a different universe, you could be engaging in these amazing stories. Do you remember those choose your own adventure books where you said turn to page this and turn to page this? You remember these as a kid, right? You can make your own adventure. I would always die in those books. I always make the wrong choice, and I would always die very quickly, which explains a lot, actually. But it's like your spaceship crashed. Oh, again. Then you start cheating and trying to figure out the right way to end the book. But the issue is, Scalia says there's nothing different. Now, Kath, did you play video games? Either one, I don't know. Does anyone actually play video games like deeply? And does anyone? I want to talk to a gamer who agrees with Scalia that there's no difference between playing a game and reading a good book. You want to go for it? Explain. I don't play video games. As you can probably tell, I have very bad hand-eye coordination, and I never beat Mario. I was so bad. I can't. I can't. So explain to me how you think that playing these sorts of immersive games makes you similar to a book. What are you thinking?
Well, it's kind of similar to how film was criticized when it was first coming out. It was
Okay.
really looked down on as it was a pretty simple medium. People thought that it was going to be a fad, and
Yeah.
video games is kind of the new film industry. That it is really just you've got a story. Maybe not all games, like Candy Crush is not going to have the same kind of thing, but in many instances, you have a story that is simply being told by pixels rather than words on a book.
But what about your involvement? You're actually driving the character around and shooting people and blowing stuff up.
You You could be, but usually there's a lot of character development. There might be some kind of themes involving maybe political undertones or something, some kind of symbolism thrown in there. There's a lot of ways to get a message across.
Interesting. Any other gamers want to speak up? I have no video game experience. Yeah, Marissa.
If you play long enough, it'll read like a book. Like I think that's basically what Dan was saying.
Really?
You have a lot of stuff. I think there's certain. I don't play as much as I used to when I was like, in high school or even younger than that. But now that I go back to it, it feels like reading a book again, because I remember little things, and then I remember kind of how I felt when I reached this point.
Interesting.
I mean, if you immerse yourself in a medium deep enough, you won't be able to tell the difference. All you'll see is the knowledge. I think.
Yeah, Sam, you want to add something?
I just was actually had some friends who were English majors, and they wanted to be writers, which of course is a bad decision in this day and age. But they found,
unlike law school.
Yeah. But they actually found work writing storylines
for video games.
Interesting.
Yeah, scripts.
Because as video, and I actually, when I was a kid, I was given a choice between video game and air rifle. So I never got into video games, but
God bless Texas.
But as the video games get more complicated, there's actually a very increasing standard of, well, I don't just want to kill this monster. Why do I want to kill this monster? What is my motivation?
Why is he a monster? What made him a monster?
Why is he a monster? What is the big?
Because he incorporated, right?
Actually, so there's real argument that you have a new form of literature developing.
Charles?
Well, I mean, I played Mario 64, and I just went back last year, and I had to get 100 stars to congratulate Yoshi. So I was.
You didn't have to.
I couldn't do it now. I got stuck on 30. But I'd like to say there's a lot of parallels between like the Homeric hero story. Like you get a magic weapon as the stars, and you have to fight the like trying to save the princess with the hero's quest. I mean.
Okay. All right. So I've heard enough from the gamers, right? So let's hear the other side. Has anyone been actually like had experiences with like the use of these video games and how it's altered perhaps minds not for the best, along the lines of Justice Breyer discussed? Does anyone have any experience with this? Wow. Yeah, Luis, you want to raise your hand? Yeah.
Yeah, I mean, every time I play a game, I lost so far.
Oh, one at a time, please, one at a time.
A game about cars or a game about guns and stuff like that. I kind of feel like I'm the guy from the game when I'm not playing the game no more. So
really?
When I'm behind the wheel, and y'all can't lie. Like you just feel like that.
John, your hand. John, this way.
So
this way.
Do you, Luis, do you actually have a wheel? I have friends who like have wheels and like have smooth pedals.
All right, you're not answering the question I want, which is fine. But I'll answer the question how I want it to be answered. So there's a general perception, perhaps any of you have kids, not maybe not in this class, but kids of video game playing. Is Nicholas playing violent video games yet or no?
What?
Does Nicholas play violent video games?
Angry Bird is probably
Will you let him play violent video games when he gets older? Okay?
I thought you were telling
Will you allow him to? I don't care how you raise your kid. Not my problem. Will you allow him to? You're a mom, okay? Your son's of age. I mean, he'll be a couple of years. Will you let him start playing like Call of Duty and
I don't see a problem with that unless he starts acting out. Then I would limit it. But that's actually Breyer's point, right? By the time he's already been playing this for years, he's acting out. Perhaps it's too late. And so Breyer's trying to get across this, I think Alito as well, is we don't know the effect of this new technology. We can't know it. So all the state's trying to do is give an assist to the parent to inhibit them. Maybe Angela's a wonderful mom. She brings her kid to class, right? But other parents might not be so involved. Maybe there are kids who stay at home all day. They go to the Walmart, whatever, and buy a game. And then they are now not on supervision. Yeah, Scotty.
Well, not to sound crazy, but on the contrary, what's to say this newfound aggressiveness is a bad thing?
What?
The aggressiveness that these games might cause is necessarily a bad thing, because if you look at drones now and the capability of the global, the Predator, the Global Hawk, these are basically for guys sitting behind a screen.
So you think we should be training people like an Ender's Game to become these warriors? Is that what you're getting at?
It might already be happening.
Okay.
There are already games similar to actual drone footage. To help
Okay.
airmen
All right.
track.
We gotta move on. Okay. I don't have enough time. Okay. But everyone get at least the core dispute. It's one of deference. Scalia applies uber strict deference, saying, look, you got to show causation. You have to have P-scores, man. You have to have a really strict determination. And the dissent by Breyer is like, let's not be so strict. Let's let the state have these sorts of distinguishers. Now, Justice Kagan, who's in the majority, said in 2011 that this was the case that she struggled most with. And she thought that she was on the wrong side. And she was worried about violent video games. And actually, to help prepare for this case, her law clerk set up a Mortal Kombat game in Chambers, where she and Justice Breyer played. Justice Breyer hated it, and Kagan said she was quite good at it. Anyway, so Kagan said she sweated over it mightily. Okay, any questions not about video games or drones on the first case? We have more to cover than I have time. Okay, but I think you'll see that the Schwarzenegger, the Brown case, I blogged about Schwarzenegger, then became Brown at the end. It was very annoying. The Brown case is a pretty good illustration of where I think the Roberts court is at with respect to speech, and we'll do a couple other cases, the Reed v. Gilbert case and the Walker case later. All right, let's go on to O'Brien. Where was that to? Okay, so what were the facts in O'Brien, please?
So you have O'Brien who burned his draft card.
Okay, now why and under what circumstances did he burn his draft card?
He burned it at a protest.
Okay, what was he trying to convey? What message was he trying to convey by burning his draft card? Good, awesome. That was the best answer I've gotten all day. They're in a high five. Very good. Just makes you think, fuck the draft, right? I tried making this point last week. If he had just been walking around Boston with a sign saying "End the War," would anyone have paid attention to him? Probably not. There were a lot of hippies back then. They blend in, right? You know, this smells about the same, right? So instead of just giving a generic message, he tried to do something very, very bold and prominent. I don't mean that in a flattering sense, but he wanted to make a statement that would resonate. So he had this entire thing where he got up on the steps of the courthouse, right, a very central place, and lit his card on fire and burned it. And if you actually read through the case, he said afterwards that he did it to try to convey a message that this war is illegal, that there are thousands and thousands of Americans being sent abroad to die, and that the only way he could draw this attention is by wearing this. I'm sorry, by burning this card. There's another case, which I don't think is in your book, maybe it's mentioned briefly, it's called Cohen versus California. And in that case, you had a guy walk into a courthouse, again, with a jacket that said, fuck the draft. I've tried to find pictures of it. None exist. I've really tried. I can't find any, but I've really tried. So the guy wore a fuck the draft jacket. Now, if he just, held up a sign saying, fuck the draft, whatever, but he had it on his jacket, like in a courthouse. It was a very prominent symbol. This is a terminello. The idea of using this shocking language that makes people feel uncomfortable is meant to open up dialogue. Because when he goes on, the steps and he burns his card, that's going to make the evening news, right? That's going to make the newspaper the next day. And then you got people saying, well, maybe it's a point. Maybe more people should burn their draft cards. And oh, by the way, if all these people start burning the draft cards, the draft doesn't operate very efficiently. You see, he's trying to basically use his own actions to spur others to take similar actions. Okay, so everyone okay with that so far? So Austin, you said you were swerving around water to get here?
Yeah.
Where was there water?
Well, I came from my parents' house, so I go on the west side.
On where?
On the west side.
Okay. So, Austin, tell me, sir, what was the purpose of the statute issue here? What did the statute at issue actually, prohibit?
Prohibited the destruction of the selected service card.
Okay, so let's do this in terms of perhaps good and bad reasons, right? What was the court's stated reason, the good reason why this law exists? And I think there's a very central reason why this law has been in existence for some time.
Just because they have the power to, raise the armies and
Good.
do anything necessary and proper to support that in goal.
Very good. Yeah, look, this is an enumerated power of Congress. They have the power to raise and support armies. And as part of that, under the necessary and proper clause, they can establish a system for selective service. They can establish a system to bring people in for the draft, right? So Shelby, why is this system then Why is it so important that people not destroy their cars? What function does this card serve?
Efficiency, so that they can, like, if they go somewhere and they aren't near their place for that, they can know what specifications they are.
Yeah, exactly. This is before computers, right? There were no iPads back then. The only way someone would know if you were registered under the Selective Service is whether you have this card, right? I mean, this was a big deal back in the 60s and 70s. If you were a draft dodger, at any point, a member of the military can come up to you and say, show me your papers. I mean, true. Show me your draft card, right? Let's see your status. If you don't have it, then they arrest you. Right? By the way, I'll mention this briefly. There was a case, I think, 1981 called Rosker versus Goldberg. Under the Selective Service Law, only men are required to register. I'm sure all the gentlemen in this room are aware. Women are not allowed. So a lawsuit was brought in 1981 saying, well, you know, it's unconstitutional that women aren't required to register for the draft. And one of the reasons why the court upheld that law was because at the time, and until fairly recently, women were not eligible for combat. So thinking was, you know, the military treats men and women differently. You know, they don't need combat troops because women cannot go into combat. Recently, the Department of Defense announced that women could opt in to combat missions. And there's a question in my mind, at least, whether Rosker is still good law under that, whether if they're both eligible for the same duties, are women now eligible for the draft? So ladies, if you have to start filling your draft card soon, there you go. So going back to this case, the court identifies that there are good reasons why the government passed this law and then amended in 1965 for efficiency, for registration purposes, etc. Now, Michelle, if you ask Mr. O'Brien why this law was passed, and really more, why was it amended in 1965, what do you think O'Brien would have told you? Why was this law amended right around 1965 when, you know, stuff was going on? If you were to ask Mr. O'Brien, why was this law amended in 1965 the way it was, what do you think he would have told you? What was going on in the United States in 1965 with respect to this case? The war. And what do you think a lot of young people with long hair perhaps thought about the war? What? Yeah, fuck it, right? They did not like the war. And one of the ways which was used to project this dislike of the war was indeed burning of draft cards. So, Michelle, let me ask you the question again. If you ask Mr. O'Brien, why did they go ahead and ban this procedure in 1965? What do you think he would have told you? What do you think Congress was really thinking when they passed this law? Cindy, you want to take a step?
Was it the same thing about being efficient?
No. What were they really thinking of? This wasn't about efficiency. What do you think they were really thinking of? Oh. Yeah, give me more. Okay. So what O'Brien says like this: even though on its face it has like a good, you know, efficiency, registration, makes sense. What was actually going on here was a speech restriction. They were trying to eliminate one of the most potent forms of anti-war protesting. They were trying to eliminate one of the most, you know, well-known and powerful messages of opposing the U.S. draft. Right? O'Brien's like, look, if they want, they can print out another damn card. People lose their Social Security cards all the time. People lose their driver's license all the time. It's not a crime to burn your driver's license. It's not a crime to throw away your passport. It's not a crime to throw away your Social Security card. They don't prosecute this stuff. What happened here was he was sitting there on the courthouse steps in a public demonstration against the war, and he lit it on fire. Okay. But the court rejects this. Natalie, why does the court reject this sort of trying to look for the evil motives inside what Congress may have done? Why does the court not go down that route?
mean, for legal purposes and trying to come to a conclusion about this particular case, that would be too abstract. Whereas they could just sort of inquire about what was the compelling interest for passing the law, if there was a good reason.
Now, Natalie, you're on the right track. Let me ask you a follow-up. Does a court see this as a content-based restriction or a content-neutral restriction?
Content-based.
Is it? Whitney?
I think it was neutral because they were saying that it combines speech and non-speech.
Okay, good. In the Brown case we just did a couple minutes ago, it was content-based because it said if it's involving killing, murdering, maiming, whatever else, right? In this case, it's content-neutral. Okay? It applies to an act, like burning a draft card, without regard to what the person's intent were, what they were trying to communicate. They said this is content-based, I'm sorry, content-neutral, because it's just about burning a record card. And the court is not interested in, pulling behind the curtain, digging under the weeds and trying to figure out what the members of Congress who voted for this were actually thinking. On its face, it's a simple record-keeping restriction, and therefore it's content-neutral, right? They're not singling out any type of viewpoint. Now, you may argue, of course they are, but the court says we're not going to figure out those motives. Okay? So, Nick, when they apply this sort of content-neutral approach, what sort of scrutiny do they apply?
Wouldn't be strict with it.
No. Well, be careful here. This is a speech restriction, right? But it's a content-neutral one. So what kind of scrutiny do they apply? It absolutely is a restriction on speech. There's no doubt. This is a speech act. We already agreed on that. But what kind of scrutiny do they apply? Okay, yeah. Good answer, okay? I don't want to even give you a label because it's not intermediate. Intermediate is something else, but you're right. It's something below strict. And the general idea with these content-neutral restrictions is that Congress can regulate the time, the place, and the manner in which you engage in this act. The time, the place, and the manner. So I'll give you an easy example. Back in the olden days, before the internet, there was these things called sound trucks. It was basically a van with a huge speaker on the roof. And they would drive through, neighborhoods saying, vote for Goldie Wilson or whatever else, right? They would project a message. Hopefully we got that. Good. Can the government regulate these sound trucks? Now, if they say you can't use a sound truck with a political message, right? That would be content-based restriction. Okay, what if they said, well, you can't have a sound truck after 9 p.m. Well, that certainly restricts your speech. You can't speak after 9 p.m. But it's not based on the content of the speech. It's based on the time in which you engage in this communication. So because it's a content-neutral regulation, the government can regulate the time where it occurs. Or if they say, if you want to hold a parade, you can't hold it. You have to get a permit. You can do it by the park. Okay? If that's the customary place where parades happen, well, then they can do that. Or another case where it says if you want to have a concert in Central Park, you have to use the city's sound equipment. That way you don't bring your own equipment. It's dangerous, cables, whatever else. That's the manner in which you engage in an act of speech. So as long as it's content neutral, the government can set the time, the place, and manner in which you engage in that speech act. You can't discriminate based on viewpoint. You can't discriminate based on content. It has to be a content-neutral thing. This is why, I think I mentioned this case last week, the neo-Nazis I can't remember, the neo-Nazi or the KKK, one of those groups, I think it was the neo-Nazis, wanted to march in Skokie, Illinois. Skokie, Illinois is a town outside Chicago with a very high Jewish population. And these neo-Nazis applied for a parade permit. And there was a very big debate. Do we let these awful Nazis march down the street, which is predominantly Jewish? And there were probably significant number of Holocaust survivors still around back then. It was in the 70s or the 80s. And ultimately, after much debate and discussion, the neo-Nazis got their permit. The city could not discriminate on their viewpoints, that they were able to then march. Ultimately, as it turns out, they never actually did it. They never marched. There was so much opposition, there's so many counter-protests, and only like a few Nazis showed up that they just called it off. But they got their permit. So these content-neutral restrictions, you can still have these sorts of time, place, and manner regulations. Okay? And that's the general test which you should learn from the O'Brien case, and a few others I mentioned. Okay? So any questions on O'Brien? Oh, yes, Luis.
So would that apply to this idea that we spoke about the safe spaces, where you know, if you're inside a certain place on a college campus, it's a place. So can they all be passed to protect against somebody's speech in that space?
Well, now you just shifted from content neutral to content based. If you're saying someone can't engage in certain acts of speech, that's a content based restriction. You only go to the time, place, and manner when it's content neutral, when you're not judging the basis of the speech. If you look at my final exam from last semester, I had a question where there was an LGBT safe space where someone couldn't say anything against gay rights in a certain area. That is not content neutral, that's content based.
Because it says specifically about gay rights. It says you can't talk about gay rights specifically.
Content-based restriction, that was a question asked last year, but any sort of content-based restriction. Right, the issue of the safe space is not merely where they're located. The issue of the safe spaces is the idea is you can't say certain things inside that will offend people. And that's a pure content-based restriction which cannot stand under the First Amendment. Make sense?
Yeah, I'm just comparing it to the political ad
The sound truck?
Example, yes. If the sound truck was of something else, not a political ad.
So this is actually the Reed versus Town of Gilbert case, right? Which we had later. Hopefully, most of you got to it. If the government says no political signs, but you can have signs for yard sales, that's unconstitutional. You can't discriminate on the basis of content. If they say you can't have any sign more than 5 feet tall, okay, that's content neutral. It basically applies consistently. In Reed v. Town of Gilbert, why this case was problematic was churches for politicians were treated one way, and then, signs for politicians were treated one way, and then signs for this church were treated a different way. And they were discriminating on the basis of the content, and that you cannot do. Make sense? I got thumbs up. Good. Yeah.
Kind of going off that, like these schools where the students will occupy the dean's office for periods of time. So can you just say
that's called trespassing?
Yes.
Yeah, I mean
they don't treat it as such.
That
I mean, you can pass
occupying is a nice word for trespassing.
You can pass a law that says you can't go in the dean's office.
Of course, I mean, offices are places of business. You can't be there unless you have a right to be there. There are certain areas where you have for example, sidewalks, streets, parks. These are public forums where traditionally you can speak. A person's private office is not. You have no right to come into my office. I mean, my door's open, you can come in, but that's because it's with my permission. No, that doesn't. Occupying is called trespassing. Yeah, it is. I'll flag briefly Justice Douglas's dissent. I told you before the guy was a loony. At this point, this was whatever year this was towards the end of his career. Yeah, I think he died in 72 or 70. I mean, he was a loony. He basically said, well, the issue in this case is not about free speech. It's about whether the draft is constitutional in the first place. And the parties didn't ask me to discuss this, but I'll do it anyway. You're drunk at home, Justice Douglas, right? It's insanity. I think I told you in a different case, some plaintiff I think it was in 1970, or 1973, tried to get the Supreme Court to stop the bombing runs in Cambodia. And the lower court said, what, are you insane? We're not going to do this. And they found Justice Douglas by himself. And he basically issued an order stopping the bombing in Cambodia. And he said, well, I'm stopping this myself because the rest of the justices can't be found, right? That same day, all the other justices reversed him, all of them, immediately. Dude was nuts. There was another case where he would always go, I think it was in Washington State, he had like a cabin, there was no phone. So you had these death penalty lawyers who would track through the woods of Washington to find him, to sign an emergency petition to stop a death penalty. And then immediately the other justice would reverse him. It got really bad. He actually had a stroke, and he became mentally, unable to do anything. And he would not resign. He refused to resign. So the justices said, in any case where he was a deciding vote, we would just re-argue it again, and they would not decide any case. They basically ignored him for the last. The guy was. This is peak Douglas right here, right? This is peak Douglas. He was a nut. Okay. All right. Any other questions on the O'Brien case? Yeah, the facts of the free speech case is always more fun than the facts of the other cases because you involve. Yeah, Samuel.
I don't think because his point, or one of the points was, but the rest of it I based on that, but where they said that they could, say convict of not having not carrying it. Isn't that the burden of the people that convicted in the first place? You're going to charge me with this, charge me with this, don't charge me with this, and then when you
the statute.
That seems like a civil procedure, kind of like, well, you
Well,
screwed up.
what's interesting, though, is the statute imposes a duty on the person to carry this card at all times, right?
Right.
I mean, there was a legitimate debate in the World War I of whether the draft violated the 13th Amendment. Was the draft itself a form of slavery? And Eugene Debs, one of the cases you'll read about later in the reading, went to jail. He went to jail because he gave a speech on constitutional law. He argued that the 13th Amendment renders the draft unconstitutional. I think there's an argument to be made. I mean, I don't have a position strong one or the other, but the law imposes a mandate. And I'll give you one better talking about mandates. During the Obamacare litigation, Congress was trying to think of mandates that were imposed on the people. And one of the mandates concerned the draft. They say you have to force someone to go to the draft. You can force someone to go to jury duty and these various other actions. Longer answer than I'm sure you were looking for. I think I got most of it in there.
Well, I was just more thinking of what they charged him for was the burning of the draft card, not
the failure to carry one.
Yeah, like
because they could just give him another card, right?
There were different subsections of the law. He was convicted under this subsection having to do with burning the draft card, not convicted under the subsection having to do with not having it with.
Because I'll leave it here, but if the problem was really that they knew he didn't have his card, they could just give him a second card, right? They could just print out another card. It's not that hard. Okay. Any other questions on? Yeah, Angela. Oh, good answer. Indeed, and I think you could have actually resolved this in the property clause, where Congress provided the rules for the disposition of federal property. I mean, if any of you have a Social Security card or a passport, if you actually look at it as you can't destroy this, or you must surrender it at the government request, like that's not your passport. The government wants you have to surrender it. Good point. Anyone else on O'Brien? All right, let's move on to Texas v. Johnson. This is the flag burning case. I think I might have mentioned this story, but I'll tell it again about Justice Scalia. This was basically a 5-4 decision. And if you imagine Justice Scalia was a swing vote joining a Brennan opinion. So the story, which I've heard from a couple people, I'm pretty sure it's accurate, is that the day after this case was decided, Antonin Scalia and his wife Maureen were having breakfast. And his wife Maureen was reading the front page of the Washington Post where it said, Nino Scalia was in the majority pulling the flag burning, right? And the story I've heard so many times, I think it's real. She started humming the national anthem. Do, 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 do. And Scalia says, I don't need this shit, I'm going to work. He stormed out. I'm pretty sure it's true. It might be apocryphal, but it's a good enough story that I'll tell it, especially now that he's no longer with us. But Justice Scalia would often raise this case as an example of voting against something that he disagrees with. He said, and this is a verbatim quote, if it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag. But I am not king. And I don't know if you noticed, but in his dissent in a Burgerfall, he had this thing about, if you think marriage improves love, go ask the nearest hippie. Did you ever notice that line? And then, who was it? Was it Crosby, Stills, and Nash? Which one's still around? Who's one that's still around? Crosby, right? Anyway, some hippie musician said, I'll tell Scalia things about love. And then there was a thing after Burgerfall. Okay. All right, what were the facts in Texas, please? Uh-huh. Uh-huh. Okay, good. So let's actually those are very good facts. I appreciate that. So what was the actual circumstance that led to the burning of the flag, Sean? What actually transpired before the flag was burned?
I believe they marched through Dallas at the
Okay.
and then it ended right on the.
Yeah, but what happened between, right? So where did you get the flag from?
It was handed to them.
It was Anderson. Who got it originally? Did they go and buy a flag at Walmart? I mean, what happened here? Where do you think they got the flag from? If you had to guess. They stole it. They stole it, right? They stole the flag. So I mean, they could have charged him with stolen property, right? They charged him with theft. That's still a crime in Texas. You can't steal someone's flag. But anyway, so Sean, go ahead. So they stole the flag, and then what happened?
Then they chanted, and then they ended up burning it for the purpose of political expression.
Okay, very good, very good. So John, tell me, sir, what message was Mr. Johnson trying to convey by dousing the flag in kerosene in front of this massive protest and lighting a match to it?
He was trying to make a political statement.
And what was that statement?
That he disagreed with Reagan's policies.
And why did he choose to burn a flag? Why didn't he just hold up a sign? Why didn't he just choose to chant? I mean, why did he choose this specific action to convey that message?
Because he felt by burning it that way, or by taking that action, he was conveying his feelings that it wasn't unified.
Right, no, but that's the message. Why did he choose this method? Why is this method different from other methods? One of the questions, right? What? And what about flag burning would make that feasible? What about this act is why he chose it?
Because it was a symbol of nationality.
Good. Cash, why did he choose this specific act? What was he trying to do? He had a very specific goal in mind. Why was he trying to offend certain people? There's a purpose. There's a reason why. Why do people use outrageous language? Why do people use these sorts of outgoing fuck the draft, right? Burning a draft card, burning a flag. Why are they doing these outrageous things? What are they trying to get? More. Draw attention. Exactly right. They were trying to draw attention, right? There were probably hundreds of protesters at this rally. And, none of them got arrested except for this guy. He did this because, you know what? I'm going to be the biggest badass here. I'm going to light this flag on fire, and everyone's going to be watching me. And then when they're watching me, I'm going to convey my message. I'm going to have the biggest stage here. I'm going to have the biggest platform, and I'm going to use this platform to convey my message about Reagan, whatever else you want to convey a message about, right? Everyone get that? The reason why they use these jarring things like burning a draft card and burning a flag and wearing a fuck the draft jacket is they want to get attention for themselves, right? I'm sure any of you have children or younger siblings. Kids do dumb stuff to get attention because they're bored. They want to get attention, right? Angela, does your kid ever do dumb stuff to get attention? Wow. Well, I was not like your kid. People make a fuss to get attention for themselves, and that's exactly what Mr. Johnson was trying to do here. It's indeed true. You guys are all right that the flag is a symbol of American unity, but the reason why he did this was to offend people enough that they looked at him. He made it on the evening news. He made it into the newspaper. He also made it into jail, right? That was probably the part. Maybe he anticipated. I don't know. Maybe he knew he'd get arrested. Maybe he wanted to get arrested. I mean, there's actually a tradition of civil disobedience where people try to get arrested for doing things they think are protected by the Constitution, and they want to challenge it in court. They want to actually make the arrest into a public incident to bring attention to their goal, right? Having sit-ins, right? Not moving when protesters tell you to move. I'm sorry, when the police tell the protesters sitting down in a restaurant that's segregated, right? People said, we're going to get arrested, and you're going to have to drag us out of here in cuffs because we're not going to move. This makes for very good TV. I'm not trying to diminish this, but it's a deliberate and I think effective strategy to get your message across. Holding up a sign doesn't do it. Getting dragged out in handcuffs, yeah, that goes on the evening message, evening news, right? We discussed religious liberty, but the incarceration of Kim Davis in Rowan County, Kentucky this summer was entirely counterproductive because it martyred the woman. When someone goes to jail, they become a martyr. Whether it's good or bad, doesn't matter. It makes attention. Okay. So we go here now. So the tricky issue about this case, Alexa, what was the Texas law at issue? What did the Texas law actually say? What was against the law here? Well, specifically, how was the law framed? What exactly was against the law here? It's important of how the law was actually framed. The desecration of a venerated object. Exactly. What does that mean?
Like destroying something.
Venerated means respected. Means respected. Okay, very good, very good. Thank you. So, Morgan, let me ask you this follow-up question. How is this law different than the draft card burning case we did a couple minutes ago in O'Brien? How is this law different? Because the court came out totally differently. How would you distinguish the draft card burning law and the venerated object burning law we have in Texas, or had in Texas, I should say? Good. Okay. So the court says that this restriction is content-based. Now tell me, why is this content-based? You're exactly right, but why is it content-based? Well, that's true, but why is it content-based? What about this regulation? Yeah. It singled out one type of object that you could burn, a venerated object like the flag, right? You could burn whatever you wanted. You could burn paper, you could burn a book, you could burn the Bible, maybe not the Bible, but you could burn, it might be venerated, but you could burn, burn copies of your textbook after the semester, right? Too expensive. Fair point, fair point. I remember when I was in middle school, I had a kid in my class, when we were reading a book, you'd rip out the page after you read it, and then the semester handed him back the empty cover to the teacher. So this book singled out specific objects based on their content, indeed, based on the message they're trying to convey. So the court finds that this is a content-based restriction. It's expressive, even though it's not a speech act, right? He's not saying burn the flag. He's literally taking a lighter and kerosene and lighting the flag on. But this was meant to convey a message, and the Texas statute was meant to prohibit the conveying of that message. So the big difference between this case and O'Brien is the court found that the draft law in O'Brien was content neutral, whereas the flag law in Texas was content based. Okay? Everyone get that much? Yes? That was going to be the next question. My next question was, I'll ask you, is there really a difference? No, see, I was telling you what the court said, but I think your question is astute. Is there really then a difference between these two cases?
The only difference is that it was a government property.
Good. Good. Charles?
Utility versus representation. Like,
you're gonna have to explain what you mean by that.
The card had some kind of social utility.
Ah.
Whereas
Okay.
the flag is it's just off.
Okay. Anyone else want to take a stab? Yeah, Tariq.
Symbolic.
Symbolic. Okay, you're on the right track. John, your hand was up.
Yeah, so I think symbolic is still go back to representation or something. I think they still revert back. So.
Okay. Dylan?
Would the state have an interest in preserving draft cards where they can't provide an argument as to what interest they would have?
Okay, I think a lot of you have more or less circled the answer I was looking for. So Justice Brennan's opinion identifies two possible interests of why this is different than O'Brien. The first one is to say, well, look, Texas says we need this statute to prevent breaches of the peace, right? If people are burning these flags, it's going to create violence. And if people are creating violence, there's bad stuff. So it's not about the content. We just want to prevent violence. This is the heckler's veto I talked about last time. This is saying basically, I'm engaging in constitutional activity. I'm doing it to piss you off. I piss you off and you come and beat me up and I'm getting silence? No, thank you. So they reject the heckler's veto. And indeed, Brennan says in some of a side note, there's no evidence that anyone actually tried to beat the guy up. People were offended that someone buried the flag, the ashes, whatever, right? The second interest, though, is the one they spend most of the time. And I think a couple of you said this, that Texas wants to preserve the flag as a symbol of nationhood and national unity. And Justice Brennan says, look, I agree, guys, right? I agree the flag is a symbol of unity. It's so important. But the fact that it's so important is why he's burning it. And the fact that Texas singled out this one object for protection makes it content-based, right? The fact that they're protecting it because of what the message it conveys, because it conveys national unity, makes it a content-based restriction, which then provides for strict scrutiny. Brennan writes that the First Amendment invites dispute, right? And we can't ban ideas that are disagreeable on the presumption that, you know, they're going to provoke violence. The idea is we're protecting this specifically because burning will make people angry. Yeah, Charlie. Charles.
Pretty much answered it.
Good. I like that.
If-
I like complete thoughts, yeah.
Incited violence, if there would have been.
Okay, that's my next point. Good. So let's go to Christine. What about fighting words, right? What about Chaplinsky, the case we discussed last class, right? If I tell you you're a goddamn fascist, you're a goddamn racketeer, and it makes you want to punch me. Imagine you're a vet, right? And your buddies were all injured or killed in war, and you came back with a war wound, and you're patriotic as they go. Your name's Uncle Sam, born the 4th of July, right? And you see this dude burning a flag. Aren't you going to knock the guy out? What about the fighting words? How do we reconcile this with? I mean, she asked, how do you reconcile this with O'Brien? I'm asking you, how do you reconcile this with Chaplinsky, the fighting words case? How does Brennan try to reconcile this? Good, good. Good. DeLaurme, you want to take another stab at it? I mean, how is this different than Chaplinsky, the fighting words case? What does Brennan say? He addresses it briefly. Yeah. Brennan basically says, and he's very, I mean, again, Brennan was the best at what he did. He says, no reasonable onlooker would have regarded Johnson's burning as a personal insult or invitation to fight. Notice he says reasonable. He basically says, again, Brennan was the best at what he did, right? He basically says it's unreasonable for someone seeing the flag burning to think that's a personal insult. See, the word personal's in there also. That this wasn't directed at anyone. It was directed at the flag. This is not like he was burning a picture of the Pope or something, I don't know, or burning a picture of someone specific. That might be viewed as a threat. The burning of the flag is directed at the country and directed at the nation as a whole. And because of that, Brennan says it's not reasonable for someone to view that as an invitation to fight. I think if there are any vets in the room, this is probably not a widely shared sentiment, but just as Brennan's definition of reasonableness perhaps varies. John?
So is the job card inciting someone to fight because it's personal?
Well, that wasn't a ground on which they upheld the statute.
Yeah.
But I think the same rule would apply as seeing a draft card burning
Or his draft card, not just like.
his own draft card.
Yeah, yeah.
Under this rule, it would not be inciting one to fight. No, because it's its own card. Okay. Yes.
What's the difference between burning the flag and burning a cross?
Wow. Okay. So there's a case reference called Virginia versus Black, which is I think it was from 2003. I might be off on the year, but it's about 2003, so you can check the year on this. And the question is whether merely burning a cross, which is a common symbol of the Ku Klux Klan. By the way, it's Ku Klux Klan, not Klu Klux Klan. People mispronounce at the last. By one of the recent debates, a candidate mispronounced it. It's Ku Klux Klan. So it's a common tool of the KKK. If you're merely burning the cross, that's protected. It's only when it's combined with a certain other crime that it becomes problematic. So if you're burning a cross on your yard or whatever, you can do it.
So you're burning it in a public place, and that's
Well, so then it goes to time, place, manner, right? Generally speaking, to have some sort of public gathering and light something on fire, like even if you want to use a barbecue pit at the park, you have to reserve in advance, right? Right? You don't? Oh, in New York you do. In any event, usually to use a public park, you have to reserve it. I don't think most parks allow burning outside of a limited thing because it could create, I don't know, forest fires. So perhaps if you had a controlled burn of a cross inside of a barbecue pit, I suppose maybe that would be allowed, but not like a massive cross burning like you'd have at a Klan rally. Okay. Everyone with me so far? Okay. So again, the majority says it's content-based, and then Brennan says, well, the best way to honor the flag is to salute it while it's burning. Hey, Brennan, I don't know where he gets this stuff from. I'm sure it sounded good on the way out, but it doesn't read so well. So the dissent by Justice Rehnquist effectively said that the flag is the most visible symbol of our body as a reverence. He would just said this is like Chaplinsky, and that this is an incitement to violence. Justice Stevens, who also served in the military, said that the flag is different from other symbols. They would single this out. Any questions on the case itself in Texas versus Johnson? Yes, Helen.
So it's not specifically about the case, but I wanted to ask one example for
Yeah.
the situation. So I have a friend who experienced a neighbor. He came home one day and the neighbor basically had a coat, his coat or something, and he had lynched it in front of his.
Yeah, what did it?
Lynched the coat.
What do you mean lynched? I don't know.
Like he had a noose around the coat, and he put it on the tree. So would that count as something that is inciting violence? Because he knew when he would be coming home. And
Yeah, the noose cases are tricky because that may be viewed as a true threat.
Okay.
Remember I said one of the other categories of speech is not protected as a true threat. If it can be shown that he had the mens rea of doing this as some sort of threat, then there may be a problem.
Actually, it's funny you mentioned
This
that.
way, this way. Thank you.
Sorry. Funny you mentioned that.
Good, you learn.
When, I guess 2 weekends ago at my undergraduate university, a student was expelled for putting a noose around a sock monkey.
A what?
A sock monkey, a little stuffed animal.
Oh, okay.
Hanging it out of his window.
Okay. Yeah, the issue there becomes one of the true threat category, or if this is done as a means to threaten someone. And that was actually, I didn't mention, but the cross burning case is also the defendant, the government did not prove the mens rea that this was a threatening act. Apparently he did it and there was no one around. So you actually have, there's a mens rea element as well as actually is an intent to intimidate or threat. So that actually gets into criminal law as well, not just First Amendment stuff. Yeah, Scotty.
One of the things that really bothered me about Brennan's opinion, like when you burn flags to retire it, that makes it okay. And the dousing of flag and kerosene in the middle of the street and actually properly cutting it up, folding it, retiring it are two completely different things. The retirement ceremony is a million times more solemn and respectful than setting a flag alight in the street. I just feel that they're not even remotely comparable, and for him to do that is disrespectful.
This is why Scalia told his wife to, I don't need this shit. Yeah.
I thought that Kennedy's concurrence in the case was probably he had a quote in there that
Was that in the textbook or?
No,
Good for you.
Research, but
Good for you.
He said it is
Extra reading, I like it.
fundamental that the flag protects all those who hold it in contempt. And he goes on about how he thought it was like a gut-wrenching case for him, and he doesn't like the decision. But he was joining with the majority anyway because he believed that he had to.
Wait, he didn't have to.
Well, he thought that it was important that that they held the way they did. It's just that you can tell in his words that he didn't like it. But
Yeah. All right. Last comment before we move on.
It's about the flag. For some reason, but
That's okay.
All right, like one of the first things that happens if somebody takes over our embassy in a foreign country, first thing they do is they get our flag and they burn it. So I mean, if someone is to burn a flag in a public venue, and I mean, how do you determine if it's a threat? You know,
Well, in this case, and I think Brennan makes his point, I think it's probably correct, he wasn't doing this directly to any individual. He was doing this against the government, right? He wasn't threatening, you know, a person in the crowd in front of him. He was doing this as a statement against the government. So I don't think there was any evidence of a threat. Okay, real last one, then move on.
Would also be like, if it's a foreign person burning our flag, that's more like.
Well, he doesn't get the First Amendment. People outside,
obviously,
they don't get our Constitution.
The Constitution doesn't apply to them at all.
No.
But it's also, that would be more as like a foreign combatant versus a.
So lock him in Guantanamo for burning the flag. Yeah. Okay, let's move on. So the aftermath of this case is interesting. And again, I guess perhaps we live in a coarse society today, but at the time, Scalia's wise reaction was actually quite typical. And in fact, President George H.W. Bush called for a constitutional flag burning amendment. The Democrats in Congress realized that actually may pass, so instead they passed a statute banning flag burning. Of course, the federal statute was invalidated a year later on the exact same grounds as the state statute. There was, you know, they tried to make it a little bit different, but that didn't fly. What's interesting is the case was 5-4 in Texas, and then a year later the case was 5-4 again. Ask yourselves about stare decisis, right? If the justices are supposed to stand by precedent, they still think they were right the first time, and they stuck with their dissent. So the vote was exactly the same. Okay. Any questions on that? No? All right, let's talk about Renton versus Playtime Theater. Sydney, you want to tell us the facts there? A good old strip club case, right? We had there are a lot of these. There are a lot of these cases. This was before the internet, by the way. This was before the internet. Go on. There it is. Okay, very good. So the Supreme Court has held that you can't outlaw adult bookstores and adult video stores and strip clubs. You can't outlaw them. So instead they try to zone them out of existence. If they say you can't be within 1,000 feet of a residential zone, school, park, church, whatever, that's basically everywhere in town outside of the seedy industrial areas, right? That's basically the only place you can put these sorts of bookstores. So if you ever notice why in your hometown, or if you ever pass by them, I suppose, why the certain adult bookstores are in the middle of nowhere, most cities have these sorts of rules in place. You'll talk about zoning and property too as well. So what's interesting about this case is the court didn't uphold this as a restriction on speech. What they said was, well, what the city of Renton, Washington is trying to accomplish is not the restriction of adult speech, right? Of course, it only applies to adult bookstores. What they're actually trying to police are the so-called secondary effects of adult bookstores. Now, I wouldn't expect anyone in this room to have ever been in an adult establishment. Go down Richmond or Westheimer, and I'm not even going to pretend where you are, right? For whatever reason, they're all in Richmond and Westheimer. I don't know why. I live near there. It's fine. But if you notice, in front of these stores, they always have very high bushes and very high walls, right? It's meant to block view of who's going in there. The reason being is that perhaps these places of business attract not the most reputable people. There's usually gangs maybe, or drugs, or violence, or people getting into fights with the employees of the store. I don't know, whatever it is. So the city said, look, we're not trying to stop people from having the speech. We want to make sure it's just far enough away from homes and kids to avoid these sort of secondary effects of crime. And what the court says here is that this is not a content-based restriction. They're not restricting adult bookstores because of the books being sold there. They're restricting it because the effects of having this in a community, that these are near the children. And won't someone please think of the children? They're merely trying to preserve and protect the quality of these communities. It is not concerned with the message. So Renton stood for this broad proposition that when the government's restricting the secondary effects of speech, it's not subject to strict scrutiny, even if it's really going after the nature of the speech. Okay? So this doctrine was extended in a number of areas involving signs, right? You may notice in certain areas you're not allowed to put a sign on your lawn, right? So if the government says you can't put up a political sign on your lawn, that's unconstitutional. You can't do that. What if they say you can't put up any sign on your lawn? We'll say, wait a minute, that's restricting my speech. And the government says, no, 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 we're not trying to restrict your speech. We're trying to eliminate clutter. We're trying to eliminate visual blight. You ever go around the Woodlands, right? The Woodland Parkway, you won't see a single sign there. Not a one. Not a one. The reason why is that we want to make it beautiful. Sorry. I don't get aesthetics. It's my DT property. I don't get aesthetics at all. It's not important to me. But they will make things beautiful and clean and neat. So the eliminating clutter is actually eliminating the secondary effects. Visual blight, that's the magic word. Visual blight is a secondary effect the government can regulate. So I'm going to jump ahead and go to the Reed v. Town of Gilbert case, which was just decided last term. This was a big case, and I refer to it as a sleeper case of last year. The facts of the case were like this. The town of Gilbert, I think it was in Arizona, passed a law saying, well, if you have political signs, there are these sets of rules. It can be this size, you can leave them up for this number of days, etc. But if there are other signs, you have different rules. The signs have to be smaller, and you have to put them there and take them back right away. So the facts of the case were like this. You had a church that wanted to put up signs saying, they didn't have a fixed building. So every week the services were held elsewhere. So they said, this week go to Jim's house, that week go to Mary's house. And they put up signs as a way to communicate with the members of their community. But because of these rules, they basically couldn't even leave signs up all week. That's put for one day and then remove them. Something stupid. So the court, in an opinion, invalidated this law. And they said that this is content-based. You're treating different types of signs differently. But what about the secondary effects doctrine? Can't the government decide, well, these sorts of signs are more clutterful and we're going to treat them in a different respect? The court didn't even mention Renton. I and others have argued that this case may signal the court is abandoning the secondary effects doctrine. I think that would be a welcome change in the law. But the was a concurring opinion, I think it was by Justice Kagan, said, whoa, 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 wait a minute. We're not abandoning anything. But the majority didn't even mention secondary effects. Didn't even mention it. Which makes me think that the secondary effects doctrine is on weak legs. So if you've noticed, we have a very, very pro-free speech court. And a lot of these old doctrines, like fighting words, like secondary effects, are being chiseled away. It's remarkable how pro-free speech the current court is. Even though that they're divided on just about everything else, they seem to, for the most part, agree that more speech is better. Unless it comes to campaign finance. My class, I don't have time to teach you, although I wish I could. Yeah, Casey.
So why do they why do these cases still indicate the First and 14th if they've already incorporated the First Amendment?
Well, even though it's been incorporated, they still have to reference that fact, don't they? Yeah, I would. I think it's correct. I think it's thorough, if I may. All right. So, any other questions on Renton or Reed v. Gilbert? Reed v. Town of Gilbert. I'm sorry. All right. Let's go into incitement, because this is a question that a number of you have asked me about the past, I guess, 2 classes. How many of you have heard the expression, you can't shout fire in a theater? How many of you heard that? I hate Holmes so much, okay? He has infected the body politic that's all people know about the First Amendment. And whenever anyone wants to make any statement against free speech, like, oh, you can't shout fire in a theater. That case was overruled 45 years ago. It's no longer good law. You'll watch any Senate confirmation hearing, any member of Congress, that's all they know. I want to excise that from the body politic. It's no longer good law, and it was never good law because it came, anyway. So my aversion for Holmes becomes clearer and clearer as the semester progresses. But the idea of incitement to violence became most prominent during World War I. And there were a trilogy of cases decided in very short succession. Schenck versus United States, Frowork versus United States, and Debs v. United States. And these cases involved efforts to prosecute people who really spoke out against the United States draft. And Congress actually had the chutzpah to pass a law called the Sedition Act of 1918, basically like the Alien Sedition Act of 1798. They call it the Sedition Act, right? You know, we've been saying this is bad for a while, but they enacted it. President Woodrow Wilson prosecuted people for handing out pamphlets opposing the draft, for giving speeches opposing the draft, and otherwise. Who upheld all those convictions? The Supreme Court, with opinions by Justice Holmes. There was other cases involving advocating violence, and for the most part, the court upheld all of those. So until the 1960s, it was the case that the government could basically arrest you for engaging in speech that promotes the violent overthrow of the government, that opposes the state, that thwarts the draft. They could just arrest you for engaging in these sorts of speech acts. And then we come to Brandenburg against Ohio. I think I mentioned last class. Felipe, you want to tell me, please, the facts in Brandenburg? Thank you, sir.
So the a leader in
Good.
And he was later convicted on the.
Well, but let's just take a step back. How did we know where this Ku Klux Klan rally was? How did we know about it?
I don't know where
Yeah, how did we know about it? I mean, was this a kind of? I mean, how did we know about it? What were in the facts of the case? This is actually an important point. Yeah.
The guy called a reporter.
Oh, okay. Dude called a reporter. All right. I'll go back to Angela. Angela, why do you think this Klan's leader called a reporter and told him to come, film his rally, his cross burning? You're sensing a pattern here, my friends, right? The reason why the Klan burns a cross, and I won't even try and get into psychology, but it's an image that's meant to enrage people and draw attention. This was no different. The guy called a reporter because he knew if he burned his cross in his backyard, no one would know about it. Right? There was no Instagram. You can't hashtag KKK. You couldn't do that back then. That would not work. There probably is a hashtag like that. I don't know. But that didn't exist back then. So he called a reporter who brought cameras with him because he knew it would get him on the evening news. Right? That was his express goal. And then, Angela, what message did he convey during this cross burning? What was he trying to? You don't have to give me the details, but generally, what kind of message is he going to convey? Good. And what else was he announcing? How were they celebrating Independence Day? Fireworks, hot dogs. Oh, I guess stuff was burning. But I mean, what were they going to do on Independence Day? Anyone? They were going to march in Washington, right? He was at this was I think I can't remember when this happened, but at some point before July, as well before, he's like, "Look, we're the Klan. We're going to march in Washington, and then we're going to do a lot of bad stuff, and then we're going to break off, and some of us are going to go to Florida, go to Disney, or no, they'll go to St. I'm sure what's in St. Augustine. I'm not sure what was going on there, but they're going to St. Augustine, and the other branch will go off to Mississippi, which was ground zero in the civil rights movement. Okay, guy was making this message for very specific reasons. He was trying to get attention for his group and trying to convey and spread his hateful message. Right? If he had just given this speech and there were no cameras, no one would have ever known. No one would have ever known about this. Right? There were no cell phone cameras. This was the only way to get this message out there. So after this thing aired on TV, he was arrested under Ohio's what's called a criminal syndicalism law, which basically means advocating crime or advocating violence. Ohio said, we're going to arrest you because you're advocating a violent act that will occur in Washington, D.C. Now, the Supreme Court had already upheld these syndicalism statutes in a case called Whitney versus California that Holmes and Brandeis dissented in. So, Daniel, what does the court do then to the doctrine of Whitney? What do they do to it? How do they reconcile this with Whitney?
It didn't really
Oh, more than that. More than that.
So, they said it's been discredited.
Yeah, it's overruled, right? They basically overruled the case from 1960s, which is why Holmes thing about the fire in the theaters doesn't apply anymore because it's not good law, right? Yelling fire in a theater, well, first of all, it's falsely yelling fire because it's actually a fire. You're allowed to yell there's a fire. But merely shouting something out is not enough, right? What then, Cody, is a test that by the way, this is a per curiam opinion. I don't know if you noticed this. There was no author. This is what happens when we pull an unsigned opinion. I don't know. I don't think there's ever been a case where an unsigned opinion overturned another precedent, which is stunning. But Cody, what was the test that was put forward in this case of what sort of actions can be criminalized? What was the test? No, it's not about O'Brien. This is indeed content-based, so we're not in O'Brien land here. Charles, want to take a step? You got it, Danielle? No, and that's a home standard. That's no longer law. Yeah?
I know, like, three Toms must expressly advocate violence, have to be immediate, and then have to actually occur.
Exactly. Well, last one you ran a little bit of ground, but very close. Yeah, you had till the last one. Yeah. So, okay, we can advocate for violence, right? I can sit here in this class and tell you, you know what? We need to have a violent overthrow of the government. And you know what? We're gonna do this. You know what? Next week, we're gonna plan this. We're gonna, muster the militia. We'll go to, we'll meet at the where was that? The Operation Jade Helm. Like we're gonna do this, right? We're gonna do this, guys. And I cannot be arrested for it. The only way you can get arrested is if you advocate inciting or producing imminent lawless violence. Inciting or producing imminent lawless violence. Imminent. That means like now. Like now. Not like next week, not tomorrow, now. Not only that, but it must be likely to actually produce such an action. So if I'm sitting there in a park and I'm screaming and no one's even listening to me, I'm like, guys, we gotta burn this down. We gotta take down the state, right? And I'm just screaming, no one's listening to me. Well, that's not gonna happen. If this guy's yelling to a bunch of his friends in Cleveland or Columbus, wherever it was, about what may happen in a few months in DC, that's not going to cut it. So the standard for inciting lawful violence is very difficult, right? I think I mentioned this example last time, but on the evening after the grand jury didn't indict in the Michael Brown case in Ferguson, his stepfather actually got on top of a car. And it was a very tense night. And he started saying, burn this motherfucker down, burn this bitch down. And indeed, a riot ensued with burning shit down, to use the phrase. I think my exam last year, I've had a similar example of that. Was that something that could have been criminalized, right? If you tell people to burn stuff down, they do it in this very tense environment. But the point I'm trying to convey is I don't think it's necessarily true, right? I mean, was it likely to happen? Maybe, maybe not. But the test in Brandenburg is so restrictive that makes it very hard to criminalize inciting violence. Now, to reiterate a point I made last week, I don't think this test is going to be with us for long. I think, as Professor Kelso noted very astutely, the court will chip away at this, and various speech involving race and otherwise is going to be carving out exceptions. It will happen. And you see this very often where people get into fights over various issues and they try to censor the person. But I think we'll probably see this doctrine not quite as strong as it is now. All right, so questions on Brandenburg? No? Okay. So I already did read. Let's go on to the last case. Wow, I actually got through them all. I didn't think I would. Walker versus the Texas Sons of Confederate Veterans. There are a lot of Texas cases for the Supreme Court. Have you noticed that? We have I've done the math. We have a disproportionate share of cases one way or the other. I don't know why. This year alone, the Texas Solicitor General had 3 cases. I think it had more than any other state combined. So we have a lot of Texas cases before the Supreme Court. We're a good state. It's very, very litigious. All right. So you want to tell us, Caleb, what were the facts in Walker?
Sure. So there's a nonprofit group that's basically looking to commemorate
The Sons of Confederate Veterans. That's the name of the nonprofit.
They're looking to commemorate Confederate soldiers, and they proposed a license plate that has 2 Confederate flags on it. And the group that approves or denies the plates received a lot of bad messages, so they essentially denied it. They sued, and essentially they found that it was a representation of the state, and so the state was basically able to deny.
Okay. So this opinion, again, this was decided the same term as the Reed versus Gilbert case. This opinion, in my mind, was one of the most non-free speech cases that we've had in a very long time. I was actually surprised it came out this way. What's interesting is this was a 5-4 decision. And if you read Justice Alito's dissent, it reads a lot like a majority opinion where he lays out the facts. My own personal suspicion is that Justice Thomas flipped. This happens. Justice Breyer's majority reads a little bit like a dissent. And I think Justice Thomas flipped and made it 5-4 the other way. This does happen. And it's not just John Roberts and Obamacare. Judges do change their minds. And my own personal theory is that Thomas flipped, but I can't prove that. Funny? Okay. Because it's very rare that, look at it this way. Justice Thomas is very rarely the author in any 5-4 decisions because he usually takes very bold positions. By my count, I don't think he's ever authored a 5-4 case. Maybe once or twice, but almost never. Usually authors dissents, concurring opinions. So assuming he actually was the most senior judge in the majority, I don't know why he would have given it to Breyer. He would have kept it for himself. So that's why I think Breyer was writing a dissent before, and then Thomas joined on board, but I can't prove it. So this case is premised on what's known as a government speech doctrine. Okay? What is a government speech doctrine? When the government is speaking on its own terms, they don't have to follow the First Amendment in the same way. So, for example, there was a case a couple of years ago where it was in Utah, where they had a bunch of monuments for different religions that went from the 10 Commandments. And this other group called the Samum had these 7 aphorisms. It's this religion which I'd never heard of. And they requested to put their own monument with their religious tenets next to the 10 Commandments. And the city said, no. So it went to the court, and the court said, well, this is the park, right? This is the government's park. And they can choose what monuments to put up. They only have so much space to put up monuments, and they can pick and choose. And wait, isn't that content-based restriction, right? The question there was, well, no, it's not content-based because it's government speech. And when there's government speech, they can choose what messages to have, so content-based restrictions are allowed. So it made this opinion seem so simple for Justice Breyer in the majority, was they said, oh, this is government speech, right? It's a Texas license plate. And this is speech endorsed by the state of Texas. And it would be totally appropriate for Texas to say, we don't want to endorse a license plate with a Confederate flag on it. Right? So the majority opinion was very brisk, and this is why I think Thomas joined the +1, because it doesn't really make any new ground. It's just, well, this is government speech. So the government can do whatever they want. Justice Alito's dissent, which is a lot of Texas pop culture references, said, this is not government speech, right? This is a forum where Texas allows private groups to advertise. And he notes that there are license plates for Dr. Pepper, Whataburger, NASCAR, the Knights of Columbus. He says, would anyone think that a license plate with the University of Oklahoma's logo would be an endorsement of the state of Texas? Of course not. You're shaking your head. There's a message saying, I'd rather be golfing. Is that a message endorsed by by Texas saying that you should not be working? So Alito writes, this takes a long and painful bite out of the First Amendment, and it sets a dangerous precedent. So now we actually have states where you can have a choose life license plate, but not a choose choice license plate, and the other way around. And that was indeed a case decided not long after this. New York declined to have a choose life license plate, and North Carolina declined a choose choice license plate. And so long as this is government speech, what's good for the goose is sauce for the gander. Any questions on the Walker case? A brief note on commercial speech, and I'll mention this very briefly. It's a complicated test. Doesn't make any sense. Okay, it's unclear what makes speech commercial. Does it come from a business? Does it come from a private group? But basically, it's some sort of intermediate scrutiny where it's not judged as strictly as other types of personal speech. But again, the corporate speech doctrine is on the wane. It hasn't really been invoked in recent years. Oh, I can't believe I made it through that with the evaluations. Okay, questions? All right, our class for Tuesday will be our last one, First Amendment-free religion. I look forward to seeing you all then. Thank you very much. Come on up.
So this is